supporting?
The Honourable David Parker.
Mr Chairman, the Act which this bill amends is a 1988 Act.
Yeah, who said that to the committee?
Well, the Minister who was in charge of that bill before it came an Act was the Honourable Stan Rodger.
Oh.
And exactly, that was the very point I was going to make. It is still famous within the Labour Party caucus some 2 decades later that the Honourable Stan Rodger was said to have said in respect of the State Sector Act, which made some very fundamental changes to the then arrangements, that it was a minor technical amendment. It went through the caucus and it was duly passed by this Parliament. I think Stan Rodger for a period was stripped of his life membership of the PSA, later to be reinstated. But by and large, the change... Yeah, that's right. Part of life membership rather than a life membership, as it proved to be. The Honourable Stan Rodgers is still alive and well. I met him again the other day, actually, and I think he can be proud that his legislation from 1988, that minor technical amendment which slipped through the Labour caucus, is really lasted close to 3 decades before it is substantially amended. Mr Chairman, I want to make reference to an amendment made at clause 6 of the bill, which is in respect of ministerial staff who are on time-limited contracts. This is intended to be a reference to the people who are largely in quite political roles within ministry offices, whose entitlements aren't the same as normal long-term ministry appointments, because they are very political in terms of their duties, and their fortunes and services are tied to the government of the day or the minister of the day. There is and to show that that this legislation is intended to have effect across more than one legislation, the example that the Select Committee or the officials inserted was of the Honourable Able ministerial staff, or the Honourable Able's ministerial staff, a description that probably applies more to ministers of other administrations rather than this. But what the provision says is that where employees who are employed on events-based employment agreements by the department that is responsible for the employment of ministerial staff across all ministers' offices and who work directly for a minister or a minister's office rather than in a department are covered by these unusual provisions. That amendment was made at Select Committee to make it clear that we're not talking about the secondees that come from a ministry and work inside the minister's office and assist the minister, but remain a departmental official and are not party political and are defending the principles of the public service, which are neutral politically. The problem with the prior legislation was that there was not this distinction made, and despite the fact that some of the people who are under the old definitions ministerial staff and were theoretically covered by codes of conduct which required political neutrality, some of these staff who were really very political and clear in their political agencies, and it's proper that they are, were caught up in the provisions of the Act that required political neutrality. And that's fixed by the amendments that we've agreed at Select Committee. Mr Chairman, another issue which was raised by submitters that I don't think we have properly addressed in this bill, it's not so serious a flaw as to mean that the Labour Party is going to vote against it, but we did hear submissions that we have in a description sense weakened the provisions relating to equal opportunity. And the provisions that were or are in the existing Act relating to equal opportunity they're still there in some way in the replacement legislation, but they're not as up there in lights as they were. And given that there remain substantial disparities in the remuneration of women There are also substantial income gaps.
I'd actually indicated to the Honourable David Parker.
Thank you, Mr.
And the member must call. I just want to give a when the member wants, you just don't state what you want to do. You must call Mr. Chairman so that it gets my attention. All right. So you must do that. I'm giving a call to Honourable David Parker.
Thank you, Mr. Speaker. And it is a new point, and it's notable in respect of the contribution of the last member that there has been no repetition. We're actually covering new points because there are many of them to make. Mr. Speaker, now I've lost my train of thought. Oh, that's all right. One of the other amendments that is made by this legislation is, which we agree in principle, is the broadening of objectives across the state sector. But I don't want to give this too much elevation, because what is now being given statutory effect to in terms of the way in which appropriations can be voted across departments should be able to be achieved through cooperation between departments now. And it has always been the case that in respect of certain complex initiatives, they reach beyond one department. And an instance that I personally was involved in was, of course, the trying to get New Zealand's emission growth down in respect of climate change emissions. And the ministries that are touching the parts of the economy that interact with emitting industries include agriculture, obviously the energy division of MED, now part of MOBI, transport, Ministry for the Environment, to name but some. And in respect of that legislation, or the need to change our direction, cross-departmental efforts were achieved under the existing legislation. So whilst the government claims that the changes that are proposed by this legislation will ensure that you can get more cooperation across departments, I think that is somewhat of a slight to the government departments of past to suggest that that can't be achieved if there is political will to do so. So the key to that more often lies in personnel, the forcefulness of ministers, the clarity of direction from Cabinet, and the capability of the different parts of the public service that needs to cooperate in respect of achieving complex change. Mr. Speaker, the area that I didn't finish talking about in my previous contribution was this issue as to indemnity compared with immunity from prosecution. And the area that I, and I am a lawyer, felt that we didn't quite get to the bottom of is whether we are creating a lacunae, an area, a gap in the rights of an injured party where the public servant acting in good faith but in a way which is against an express instruction of their employer, because they've made a terrible mistake and they didn't read the instructions, whatever they were told by the employer, might do something that causes harm to a citizen, which gives right to a right of civil action against the public servant, but not against the Crown, because the actions of the public servant are so wrong as to not fall within the vicarious responsibilities of the Crown as the employer. And by granting immunity from civil suit, we risk leaving the injured New Zealander without remedy. Now, it's a very narrow set of circumstance, but it is, I thought, possible. And I wasn't satisfied that through this legislation we're not, because we're taking the immunity rather than indemnity route, where we're giving immunity from civil suit rather than indemnifying the public servant against the consequences of civil suit. I think there is a possibility that an injured party can have no right of civil redress because they haven't got a right to include the public servant in a civil proceeding, and they have got no right of claim against the Crown itself. So I thought the Law Commission advice in that regard was correct, and that we shouldn't try to be fixing in this legislation. We should await the review that the Law Commission has underway into that serious point of law. Mr. Chairman, the other point I was going to make will have to wait for a later contribution.
Chairman.
The Honourable Trevor Mallard.
Very good choice.
Mr. Chairman, I've had some experience working in this area as Minister of State Services